This is Constitutional Rights in Black and White.
In 2010, there were about 2 million people of Latina descent in Arizona, nearly one-third of the state's population. Demographic changes in this politically conservative state promoted notable anti-Latina political backlash in 2010. At that time, the state's largest sheriff's department was engaged in racial profiling practices so severe that the U.S. Department of Justice initiated an investigation of the department's pattern of civil rights violations. The state legislature attempted to ban a popular Mexican-American studies program in public schools that same year, though a court eventually struck that ban down as unconstitutional. And relevant here, the state's legislature passed SB 1070, a law targeting non-citizens with arrest and criminal penalties for immigration-related offenses, even though immigration is primarily the power and responsibility of the federal government. SB 1070 made it a state crime for a non-citizen to fail to register with the federal government or to work without federal authorization, even though neither of these things are crimes under federal law. The law also required Arizona police officers to guess the immigration status of people they stopped for traffic and other violations, even though they had no training, expertise, or federal authorization to engage in immigration enforcement. SB 1070 sent a wave of fear through the Latina community, and several organizations brought lawsuits to enjoin the new law. The federal government also sued the state of Arizona, and that case went to the U.S. Supreme Court. The federal government argued that immigration is a matter of federal authority, and that Arizona lacked the power to interfere with it by passing this kind of law. Basically, yes, said the Supreme Court. Congress's immigration authority is part of its inherent power as a sovereign to control and conduct relations with foreign nations. The Constitution states that federal law shall be the supreme law of the land, which means that Congress has the power to preempt state law. Great, said the federal government. 4 provisions of SB 1070 are preempted by federal law. Mostly yes, said the Supreme Court. You are probably right on 3 out of 4 of them. For law criminalizing failure to register, the court noted that the federal government already had its own regulations and penalties. The federal government has occupied the field of alien registration, so Arizona cannot pass a law in a legislative field that is fully occupied by the federal government. As to the provision that makes it a crime to work without immigration papers, the court found that Arizona law conflicted with the objectives of the federal scheme. The federal legal framework reflects a considered judgment that making criminals out of aliens engaged in unauthorized work would be inconsistent with federal policy and objectives, said the court. In other words, Arizona law is preempted here, too, this time because it creates an obstacle to federal objectives. And arresting people who might be removable? That violates the principle that the removal process is entrusted to the discretion of the federal government. That provision is preempted for creating obstacles to federal enforcement objectives, too. But wait, said Arizona, immigration deeply affects this state. We should have some legislative say over it. You're right, said the court. The pervasiveness of federal regulation does not diminish the importance of immigration policy to the state. But at the end of the day, Arizona cannot pass a law that stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. What about Section 2B, said the United States. That provision requires Arizona police to determine the immigration status of any person they stop, detain, or arrest if reasonable suspicion exists that the person is unlawfully present in the United States. Federal law does not require state immigration checks like these. Also, the requirement is an open invitation to racial profiling. Aside from relying on racial appearance, how else are police, untrained in immigration enforcement, going to guess that a person is unlawfully present in the U.S.? We're not ready to decide this one, said the Supreme Court. It's not clear how this provision is actually going to work. We should not decide before the state courts have an opportunity to construe it, and without some showing that enforcement of the provision in fact conflicts with federal immigration law and its objectives. Arizona versus U.S. teaches us an enormous amount about immigration law and about the relationship between the state and federal governments on this all-important question. And even though immigration law is technically civil and not criminal in nature, the case also reveals just how tight the connection is between immigration and criminal law. Okay, let's read the case. Arizona v. U.S. is a case about federalism, the division between the federal government and the state government of lawmaking authority. Specifically, it's about the power of states, in this case Arizona, to pass a law that empowers its own agents to participate in immigration enforcement, and that criminalize immigrant residents in ways that federal law does not. In 2010, Arizona passed a law with a stated purpose to discourage and deter the unlawful entry and presence of aliens and economic activity by persons unlawfully present in the United States. SB 1070 made it a crime for non-citizens to fail to register with the federal government or to work without federal authorization. The law also enhanced Arizona police authority to arrest and detain people based on their immigration status, actual or perceived. The law was especially controversial with respect to Section 2B, which required Arizona police to guess persons' immigration statuses, a provision widely understood to invite racial profiling. The U.S. argued that 4 of SB 1070's provisions were preempted by federal law. The Supreme Court agreed that the U.S. was likely to prevail on 3 out of 4 of these claims, but the court allowed Section 2B to go into effect, while leaving the door open for further challenges based on how the law was actually implemented. This case takes place against the backdrop of the federal government's broad immigration authority. The Supreme Court has held for decades that Congress's immigration authority is intimately connected to its power as sovereign to control and conduct relations with foreign nations. Although there is no express provision of the Constitution describing Congress's immigration power, since the mid-1800s, the court has treated immigration authority as implied in the national sovereign power. The federal government's immigration regulatory structure is extensive and complex, and is characterized by an enormous amount of discretion. States also have an interest in immigration. The Supreme Court goes out of its way to describe Arizona's immigration concerns as pressing. In particular, the court cites anecdotal evidence and the inaccurate reports of restrictionist researchers regarding immigrant crime rates as ways of emphasizing the potential cost of immigration to the state. The technical issue in this case is whether Arizona law is preempted by federal law. The Supremacy Clause of the Constitution states that federal law shall be the supreme law of the land, which means that Congress has the power to preempt state law. Preemption occurs expressly when Congress writes a statute that preempts or otherwise forbids states to legislate. Preemption also occurs implicitly when federal law exclusively and pervasively regulates an arena referred to as field preemption. Preemption also occurs implicitly when state law conflicts with federal law, so-called conflict preemption. Even if there is no direct conflict, that is, even if it is technically possible to comply with both federal and state law, a state law can be preempted if state law stands as an obstacle to the full purposes and objectives of Congress. This is known as obstacle preemption. The court then analyzes each of the 4 provisions of SB 1070. Section 3 makes it a crime for non-citizens to fail to register. Federal law already has a complex array of registration requirements, including criminal penalties for failure to do so, and the court concluded that the federal government has occupied the field of alien registration and thus preempts state law. Here, the court relied on a 1941 case, Hines v. Davidowitz, in which the court decided a virtually identical question to reach the same conclusion. Section 5C makes it a crime in Arizona for undocumented persons to apply for work, solicit work in a public place, or perform work as an employee or independent contractor. In 1986, Congress passed the Immigration Reform and Control Act, in which it decided to impose penalties on employers who hired unauthorized workers, but not on the workers themselves. The statute expressly bars states from imposing any additional penalty on employers, although it is silent about whether penalties may be imposed on workers. In light of this congressional action, the Supreme Court held that IRCA's framework reflects a considered judgment that making criminals out of aliens engaged in unauthorized work would be inconsistent with federal policy and objectives. Arizona's law is thus an obstacle to the regulatory scheme Congress chose and is therefore preempted. Section 6 authorizes Arizona police to arrest anyone they believe to have committed any offense that makes them removable from the United States. A person is removable if they have committed any of the criminal offenses or civil statute violations identified in the federal immigration laws as a basis for deportation or exclusion. Even if a person is removable, she may have a defense to removal. Many people in the U.S. are removable because they have not received authorization to be here, but it is not criminal. Federal law does not make it a crime for a person to be present in the United States without authorization. Here it is important to remember the civil-criminal distinction. Immigration law is civil and administrative. If a person is removable, an immigration court will issue a notice to appear at removal proceedings. Only in limited circumstances would a court issue an arrest warrant. By contrast, Arizona's SB 1070 allows for arrest at any time an officer believes a person has committed a public offense that makes them removable. The court held that this broad and ill-defined section violates the principle that the removal process is entrusted to the discretion of the federal government. It creates an obstacle to the full purposes and objectives of Congress. Accordingly, this section is preempted. The court then turns to Section 2B, which requires state officers to make a reasonable attempt to determine if the immigration status of any person they stop, detain, or arrest, if reasonable suspicion exists that the person is an alien and is unlawfully present in the United States. This was a highly controversial aspect of the law and received a great deal of media coverage, largely because it was understood as an invitation to racial profiling. The provision contains a limitation that states that officers may not consider race, color, or national origin except as permitted by the U.S. and Arizona's constitutions. But this provision turns out not to be much of a limit, since the court previously held that use of race, specifically reliance on Mexican appearance, among other factors, is constitutionally permissible in immigration policing. Here, the Supreme Court decided not to decide. It held that merely requiring police to determine a person's immigration status was not on its face contrary to federal policy, since federal law already requires ICE to respond to such inquiries from state officials. The court acknowledged that prolonged detention in connection with immigration inquiries might violate the Fourth Amendment, and also that it was possible that the law would be implemented in ways that were racially discriminatory. But it refrained from deciding whether this possibility might invalidate the provision. This is the difference between a facial challenge and an as-applied challenge. The federal government challenged SB 1070 on its face as impermissible under all circumstances. By withholding judgment, the court left open the possibility of challenges to the law as it is actually implemented in Arizona. Justice Scalia dissented, arguing that Arizona had the power to pass SB 1070 as part of its sovereign power to exclude people from its own borders, and therefore that SB 1070 should not be preempted. His dissent represents a substantial departure both from the reasoning of the majority and more broadly from modern treatments of immigration, sovereignty, and international law. Justice Scalia's view is that federalism should give states more power to have their own immigration policy and international affairs separate and apart from national policy. Decisions about preemption speak to the scope of federal authority, with implications not only for immigration, as in this case, but also for drug policy, safety and health regulations, education, environmental regulation, and other arenas of law. These cases have ripple effects upon many areas of state governmental power. This case, for example, highlights how the federal government's power over immigration affects not only migration policy, but also state criminal law and law enforcement policies. Indeed, this case well illustrates the tight connection between the nation's putative civil federal immigration system and the nation's state and local criminal legal systems. SB 1070 is just one example of how state criminal law and its enforcement directly determines which immigrants are targeted for federal immigration enforcement efforts. This remains true even after the court's strong reassertion of federal immigration power in Arizona versus U.S.
I'd like to thank Professor Jennifer Chacón for contributing this important case video to CRBW. Professor Chacón is the Bruce Tyson Mitchell Professor of Law at Stanford Law School. Her cutting-edge scholarship explores the nexus of immigration law, constitutional law, and criminal law and procedure. We're grateful that she took the time to share her work with us.